Hello and welcome to today's program, Steering Clear of Lawyer Discipline. This program is brought to you by the ABA Law Student Division, the ABA Center for Professional Responsibility, and the ABA Young Lawyers Division. My name is Kareem Arif. I'm the chairman of the ABA Law Student Division, and I'll be serving as the moderator today. Joining us are Ellen Rosen, who is Deputy Director of the Center for Professional Responsibility with the American Bar Association in Chicago, and Wendy Wen-Yun Chang, partner with Hinshaw and Culbertson LLP in Los Angeles, California. Before handing off to Ellen and Wendy, I would like to remind law students that ABA membership is free. The ABA has just introduced premium benefits, which includes a savings of $250 on a Barbary Bar Review course and $25 off of West Academic Casebooks and Legal Ethics bundles. And this includes a free Model Rules of Professional Responsibility Conduct or Professional Conduct ebook, and it only costs $25 to get all these benefits. So sign up today at abalawstudents.com/gopremium. Ellen, can you get us started?
Sure, thanks, Kareem. So usually we spend about 90 minutes or more on this topic, but we've got a short time today, so we're going to just highlight a few areas for you to keep in mind for after you graduate, pass the bar, and enter into practice. These are areas where, in our experience, it's really failing to pay attention to the basics that can really end up kind of biting you in the backside from a disciplinary perspective, as well as a malpractice perspective. So these tips focus on really sound practice management skills. And before we get into that, there was a slide with about the Center for Professional Responsibility. So we here at the center are here to help you. And please go check out our website. We've got a ton of resources, a ton of free resources. And you can also find contact information for myself and my colleagues here, and we're always happy to answer any questions that you have regarding ethics and professional responsibility matters. So before we start talking about our tips, I want to describe to you a little bit about the disciplinary process, just briefly how it works. It's a complaint-driven process primarily. In every jurisdiction, there is a disciplinary agency. Sometimes they're agencies directly of the Supreme Court. Sometimes they are operating out of the State Bar Association. But regardless of where they operate, they typically proceed in the same way. As I mentioned, this is the system where they are responsive to complaints. Typically, anybody can file a complaint. And what happens is, once those complaints are filed, they get screened out. If they don't fall under the jurisdiction of the disciplinary agency, they get screened out and what we call summarily dismissed. Otherwise, they get investigated by the professional disciplinary counsel that staff all of these disciplinary agencies around the country. The investigations are confidential. They seek information from the complainant, from the lawyer who is in receipt of the complaint. They may gather additional information. And then they determine whether or not there appears to be probable cause that the rules of professional conduct have been violated. If that's not the case, the matter is dismissed. They remain confidential in virtually all jurisdictions with the exception of 3 or 4 at that stage. If they determine that a formal disciplinary prosecution is necessary, those formal charges are filed, and those matters proceed in the same way that most civil cases proceed, except that the adjudicators tend to be 2 lawyers and a non-lawyer who act as an adjudicator. There are due process provisions that apply in disciplinary cases, not the full panoply that you would get in a criminal case, but you do get due process. And as I said, the matter proceeds as it would in most civil trials. And at the end of the day, it's ultimately up to the court if they find, if there is a found violation of the rules of professional conduct, what discipline is appropriate. So what do you if you get a complaint? And I will tell you that most lawyers at some time in their career are going to get a disciplinary complaint. It's just the nature of the beast. So some quick things to do and not do. Because when you get this letter, if you see it, you're going to see it comes in the mail and it comes from the disciplinary agency, and that's going to get your heart beating. Open the letter. You would be surprised how many ostriches there are out there who simply put the letter in a drawer or throw it away and don't open it, and you're just going to buy yourself more trouble down the line. Try to remain calm, read the letter carefully, identify the nature of the complaint. Consider hiring a lawyer to assist you in responding, or have a trusted colleague review your response. Don't conclude that you're going to look guilty if you hire a lawyer, or don't be embarrassed to seek input or advice. Take a look at the professional conduct rules, and more importantly, take a look at the disciplinary procedural rules. We often, find that we're going to look at the professional conduct rules because that's what you're alleged to have violated, but the disciplinary procedural rules matter just as much. And I will tell you that sometimes what you will find in the disciplinary procedural rules is that certain actions you take or do not take could wind you up in more hot water. So prepare your written response carefully and thoughtfully if you don't have counsel. Don't be angry. Don't provide irrelevant or false information, and address all of the issues. And then put that draft aside for a day. Just let it sit for a day before going back to it, and then go back to it and make sure that you haven't written in anger or sarcasm and that you've addressed all the issues professionally. And of particular importance, make sure that you are not revealing client confidences unless it's necessary to defend yourself against the charge. A lot of lawyers find themselves in more trouble by doing that when they're responding to a disciplinary complaint. So that's a quick overview of the disciplinary process to give you a little context about what we're talking about as we move forward with the presentation. And so we're going to start with the importance of client intake. And the rest of what we're going to talk with you about today really focuses on this. It's about getting your clients, keeping them, and keeping them happy. And your client intake practices are the first and most important step in doing that. The training that you are receiving in law school may not necessarily prepare you for that sufficiently. So if you're going to hang out a shingle, whether that's physically or virtually, plan ahead. Before you open your doors or your website, become an educated consumer. Learn about strong law practice management systems. And if your jurisdiction has a law practice management advisor, consult with that individual. They can be invaluable to you. Wendy's going to talk to you a little bit more about client selection in just a minute. But one of the most important things is to know that you don't have to take every potential client that walks through the door. If you practice what they call door law, you're asking for trouble. So develop a checklist for your client intake that's going to help you evaluate your client's needs, assess their goals and expectations, and most importantly, determine whether you're competent to handle the matter, because that's required by the rules of professional conduct. Rule 1.1 is competence. And don't be embarrassed to tell a client, a potential client, that you don't have sufficient expertise in a particular area of law. You have an obligation actually to do that. You can always, with the client's consent, refer the matter to a more experienced lawyer or consult with a more experienced lawyer to assist you in the representation. And we'll talk a little bit more about that, working with other lawyers when we talk about fee division. So some wise words for you to keep in mind. And that is, expectation is at the root of all disappointment. Getting clients and keeping clients happy, which means they're more likely to pay you, is as much about setting and managing expectations for the client-lawyer relationship as it is about your legal skills. And we're going to talk more with you about how to do this via use of written fee agreements and engagement letters and billing practices. The ethics rules in most jurisdictions don't require you to have a written fee agreement or engagement letter, except in certain circumstances, like contingent fee cases. But when you get down to it, it's just good common sense. Having one protects you and it protects your clients. So before we get to that, I'm going to hand it over to Wendy, who's going to talk to you a little bit more about client selection and conflicts checking.
Great. Thank you very much, Ellen. And welcome, everybody, and thank you for joining us today. The one thing I wanted to just give a framework for my perspective on this presentation is, so I defend lawyers for a living. That is my area of practice, and I've done it for over 20 years now. And so when we talk about a lot of this stuff, and Ellen and I got together and put this PowerPoint together, I think what we tried to put into it was the perspective of our collective experience in seeing a lot of these types of cases over the course of the many, many years we've been doing this. And so I think that this particular quote that is up on the screen, I think it's a really good rule of life. But when it comes to clients and managing your relationship with your clients, which is as to the core of your services as an attorney, this is probably the number one thing you can do to protect yourself from everything, and that is managing the expectations of your client. And then to do that, I think we start first with what we think is probably, if there's any one thing that you're going to spend a lot of time on when it comes to your practice, it's being very, very, I think, skillful at selecting your clients. And this is kind of hard, especially when you're young, or if you are in a situation where, and then this pretty much goes through the entirety of your career, where we are trying to build a practice, we're trying to build a business. And we tend to sometimes I think, confuse two issues. One, the issue of being busy versus the issue of being profitable. What you want is to be profitable. It's not necessarily that you want to be busy. A lot of times people conflate the two concepts, and they think that if I'm busy, then I'm going to be profitable. But that's not always the case. Sometimes you can get caught with a bad client who doesn't pay you, who ends up suing you, and who's going to pursue you for years. And at the end of that, you're going to spend a lot of more money than what you're ever going to earn. And so it's really worth it to be mindful of these issues at the outset. So I'm just going to go through a couple of categories of clients that we see pop up in a lot of the cases that we handle that turn out to be problems. So this is what we call the charming victim client. And they typically show up on your doorstep, and you're probably, there's a lot of lawyers that have handled this case before you, but this victim client has a really, really great story about how he's been victimized repeatedly, first by the initial person who the lawyer needed to sue, but then each and every lawyer who handled the case down the road. And you know, and this takes a lot of skill, because there are genuinely clients who are in genuine need out there, and those clients, and you can and you should do what you can to assist them. But when someone comes to you, and there's a lot of lawyers who have preceded you in the whole representation, and they're telling you this amazing, compelling story, you just need to be have your red flags up that there may be something wrong in this story. And the reality of it is, all of those lawyers who preceded you, and in reality, they would not be smiling. They would probably be all very upset, because this client could be difficult. This client can be someone who is unable to be satisfied and very, very difficult to manage, and somebody who will probably make a claim either in the disciplinary world or in the civil world. And so you do need to think twice about taking on these types of clients, especially if one of the things they're telling you is you cannot talk to the prior lawyers. And there are clients who will come to you and say, I forbid you from talking to anybody about this case. And if you get that client, you need to think about whether or not you want to take that case on. So the next one we have is a time-intensive client. And the time-intensive client falls into several different types of categories as well. Some of them call you in the event of an emergency. They have a pleading that is due tomorrow, or they have a filing that needs to be made right away. And sometimes this is because they genuinely just were not able to find somebody in time. But the most of the time, this is signaling a client who is not organized, or sometimes someone who may be even purposely putting you in an emergency situation so you cannot adequately evaluate the case and all of the problems with the case, and that you're simply going to jump in to save the day. But once you jump in, you're kind of caught. Because at that point in time, you are the attorney of record, and all your ethical implications have kicked in, and you can't just walk away from it. And so when you come and there's an emergency client in front of you, you've got to really evaluate, do you have enough information to make you feel that you really know what's going on? And do you have enough time to competently do what the client needs to be done? Because if you do not, it is actually a really good idea not to take that case on. And because if you make a mistake in that rush, you may have problems trying to deal with that after the fact. The next one is the aggressive client. This aggressive client tends to be someone who has very little respect for anybody's opinion other than their own, and they are very pushy. Half the time they do not really understand what the legal issues are, and they're going to try to bully you. And one of the main things about controlling the expectations of your client is maintaining respect. And if you're unable to maintain the respect of your client, you're going to have a really hard time maintaining that relationship over time. And so if they're aggressive at the outset, and you are the personality where that aggression doesn't work with your personality type, it's not going to get any better, and it's only going to get worse. If you are someone who handles aggression okay, and you think you can manage this, it is fine to take that case, but just need to keep in mind that you need to be very mindful of managing that aggression all along. The needy client is like the flip side of the aggressive client. Again, this is a question of staying on top of what the client needs, but making sure that you manage their expectations. The demanding client is very similar to the aggressive one. The lying client is a problem because you have ethical obligations and you have duties of candor. And so if you have a client that comes to you and they are lying, or you suspect that they are lying, you have ethical obligations that will trigger. And so if they come to you from the beginning and you think that they are lying, I would suggest that that's probably not a good client to move forward with. But if during the representation and you catch them lying, then you need to evaluate the nature of that lie and what it means to your own ethical obligations and determine whether or not it means you need to withdraw from it. The client who's unwilling to pay you from the very beginning will typically be someone who's unwilling to pay you later on. If they are nickel and diming you on your cost, on your fee issues up front, that's not going to get better. Now, if you are in a situation where you are comfortable with the fact that this client has a few funds and that you will not be getting paid for it, and you're willing to enter into this, into either a pro bono scenario or a very limited fee scenario, that is actually a very, very good thing, and I would encourage you guys to do that through the course of your career. But if what you have is someone who is completely capable of paying, they just don't want to, or they're just giving you trouble because they are just negotiators, and there's someone who always wants to get something from you, then you need to think about whether or not that's going to be something you're willing to go through, because typically it only gets worse to the point where you end up unpaid and with a really unhappy person who's going to come after you. The know-it-all client is the one who does all of his own little research on Google, and they challenge you and they question you and they know better than you. This goes back to maintaining respect and maintaining your control of the situation. And at some point in time, you do need to talk to your clients, and they have an absolute right to have the sufficient information that they need in order to make the informed decisions they need to make for their case. But where they are up to the point where they are completely not listening to your advice, they're saying they talked to someone else who said something different, they've looked it up themselves and they found something different, again, you need to think about managing that relationship and evaluating whether or not at some point in time you've lost control of it and whether or not you need to go forward. You need to, at the beginning, you have to address the importance of checking conflicts when you get a new matter in, and then you really have to clear those conflicts. Conflicts of interest are one of the #1 sources of civil claims today, and they are one of the most difficult claims from a defense lawyer's perspective to defend because there's a lot of fact-based disputes in conflicts, and typically your jury or a typical member of the public doesn't really understand the nuances of what we call the difference between a technical violation of a loyalty rule and just a full-scale violation of the loyalty rule. They see it all as a violation, and so they're not going to be very forgiving of it. And so while it's very, very you want to get into the case, you need work, you want to get paid, and you want to just blow through these conflicts and try to work on it, I got to tell you, you really need to spend the time and work on these conflicts, identify them, and address them, because if you don't, they will come back and bite you, I promise you. And this comes down to what Ellen said before. you really need to really understand that it is possible to say no, and you should say no. And ultimately, while you may end up with not having that work in the short run, in the long term, it could be better for you, and it probably will be better for you. And this is just something that you'll learn over time how to get better at doing. But just at the outset, when you start your career, understand that you don't have to say yes to everything.
So, communications. That's what we're going to talk about now. And this is one of my favorite quotes, not just in a professional context, but personally. The single biggest problem in communication is the illusion that it has taken place. So just like setting and managing expectations with your clients, strong communication skills are going to take you far with regard to productive client relationships and avoidance of disciplinary and malpractice complaints. And you have an ethical obligation to promptly comply with your client's reasonable requests for information, and you have an ethical obligation to keep them reasonably informed about the matter. So it seems simple, but what I can tell you as a former disciplinary prosecutor is if it was that simple, then one of the most frequent disciplinary complaints would not continue to be that lawyers are not communicating with their clients. So the duty to communicate. What you view as reasonable and prompt and what the client thinks is reasonable and prompt may not necessarily be the same. And technology adds a little twist to that. It's a double-edged sword. In some ways, it makes it easier to communicate, but the expectations of immediacy and constant contact can create problems if you don't, as we keep repeating, set and manage those expectations and document them with your client at the outset of the representation. You should, of course, maintain regular contact. Reasonably document your milestones and your communication efforts, and regular detailed billing statements can help with this. A well-informed client is typically a happy one, and as Wendy has said, a happy client is typically one who's going to pay you. And talking about payment, I want to cover a little bit with you about sharing and dividing fees. I think one of the most important things I can tell you about this subject of sharing and dividing fees is you need to know the difference. They're not the same thing. There are going to be times when you are going to work with another lawyer from a different firm on a case, and you're going to provide a client with a single billing statement for the work that both of you do. That's where you are dividing fees. Sharing fees is a different issue, and that falls under Model Rule 5.4. It typically arises in a very different context and involves questions that focus on the maintenance of your independent professional judgment and making sure that somebody who is not a lawyer is not interfering with your independent judgment. Fee division is permissible if you meet the requirements of Rule 1.5e. The division of fees has to be proportionate to each of the services that the lawyers are going to perform. The total fee, of course, has to be reasonable, and that's true of any legal fee. And importantly, and again, this is where client communication comes in, the client has to agree to the arrangement, including the share that each lawyer in this fee division arrangement is going to get. Following along with that, you have a duty to safeguard fees that are subject to division. For example, at the end of the matter, the client pays you the earned fee that you have agreed will be divided with another lawyer. You've got that total amount of the fee, and you owe the other lawyer her share. What do you do with that money? Well, you don't put it in your business operating account or in an account where you keep your personal funds. And if you take a look at new ABA Formal Opinion 475, it tells you that. And it tells you that under Rule 1.5d, which is the safeguarding property rule, that other lawyer who you've worked with and with whom you're dividing the fee qualifies as a third person for purposes of the rule. So you have to deposit those fees into your client trust account or another separate account that doesn't commingle monies with your personal or business finances. And then you have to let the lawyer know you have the money. So I think what is particularly interesting about this is while the other lawyer is a third party for Model Rule 1.15d and sharing fees, you have to keep in mind that that lawyer does not qualify as a third party for other purposes. For example, with regard to your ethical obligations under Model Rule 1.6, which requires you to keep client information confidential. So it's always important to take a look at these ethics opinions because they're going to give you that type of advice, not only about how you handle the funds, but the implications for how this scenario might play out in the context of other ethical rules. So the importance of fee agreements and billing. It's really much more than getting paid. As I mentioned before, it's a way to set and manage expectations with your clients. It's how you start the process of keeping your clients informed, and it's how you protect yourself from disciplinary and other complaints. So some things to start thinking about in this context. And I think probably most importantly is the scope of representation, because that really sets the table for everything else. What you're going to do for the client and what you will not do for the client, how and with whom you will communicate. And again, this is where you're going to be addressing issues of fees, fees and costs and expenses, advance fees. All of these issues should be covered in your retainer agreement or your fee agreement. So what happens when the money starts coming in? Well, you need to be careful to understand what your ethical obligations are with regard to record keeping and the handling of those funds. So here are some do's and don'ts. I'm not going to go through all of them because we're running a little short on time, but one of the things that I want to highlight is, and it's not just about funds, and that's know what part of the client file belongs to you versus what part of it belongs to the firm and what part of it belongs to the client. These are important things for you to keep in mind no matter what size firm you practice in. And then finally, I want to talk a little bit about confidentiality. I've mentioned it in a couple of other contexts, but the client-lawyer relationship is built on trust. And in order to effectively represent a client, you have to have all information that is relevant to the representation. The client has to feel free to share this information with you. And that's why we have Model Rule 1.6, which deals with your fiduciary obligation and your ethical obligation to keep that information in confidence. Become familiar with the rules of professional conduct governing confidentiality. Be careful about abusing your position of trust and using client information in a way you might not think is problematic, but is. And I can tell you that this arises in the disciplinary context, particularly with younger lawyers, with regard to social media. You may get a bad online review on Ava or some other social media platform. You need to be very careful about how, whether, or how you respond to that. And I can tell you this because it's landed lawyers in disciplinary trouble. One of them happened to be a friend of mine who was disciplined because she revealed confidential client information that in the context of responding to a bad review on an online platform. So seek advice if you're not certain. And remember, you can break your confidentiality obligations by doing things that just might not occur to you. You might be talking on your cell phone while you're on the train or the bus on the way into work. You may make comments on Twitter or social media. You can be disciplined if you blog or tweet about a particular client matter, even if you're using pseudonyms for the client. And I'll give you a case that happened also in Illinois, where an assistant public defender was suspended for 60 days because she posted confidential client information and discussed it in her blog, even though she used a pseudonym for her client. Another thing that is going to be coming up, especially with regard to the use of technology and other forms of outsourcing, and by technology I'm thinking in particular of cloud computing, you are responsible for safeguarding client confidences when you deal with third-party vendors. You have an ethical obligation to take reasonable steps not only to prevent the unauthorized or inadvertent disclosure of that information, but the unauthorized access to it. So in the context of cloud computing, you need to keep that in mind. You need to make sure that your cloud provider, for example, has in place sufficient security measures. So that's what I wanted to touch on with regard to confidentiality so that we have enough time for Wendy to finish up with prospective clients.
So I always like to talk about prospective client issues because especially I think this is where there are potential real problems because the lines start to gray a little bit. So a prospective client is technically anybody who comes to you seeking legal advice. And there is a rule, Model Rule 1.18, that covers that scenario. But for your purposes, you need to recognize that this does not necessarily always happen in a formal setting. And sometimes people are asking you for legal advice. You'll see this on social media. You're probably getting this a lot now, even while you're in law school. People, they have, quote, quick questions. And they want to just, talk really briefly about something. And can I just talk to you about stuff like this? And you need to really think about every single time you get a question like that, either in the formal, we want to hire you, or in the informal, let's just talk, and you guys are at a party. These are potentially prospective clients. And so you need to think about what the rule requires you to do. And you do need to think about potential conflicts with existing clients, and this will happen when you are practicing in the future, or if you are currently working at a law firm. You have obligations that your law firm has towards the clients of the law firm. You don't want to be talking with a prospective client about an issue that is adverse to one of your law firm's current clients. And so typically what you need to do, and people get really upset about this because we come off really, really rude, but I want to talk to you, but you have to actually cut in there and stop. Before you talk to me and give me any information whatsoever, I have to do a conflict check. And unfortunately, that makes you unpopular sometimes, but the reality of it is you really do need to do it. You need to watch out for what we call pitches and beauty contests, and this is something that clients now are really, really starting to really want from prospective lawyers, and they want lawyers to come in and kind of like bid and kind of talk about why they are the best lawyers for that particular case. And the more and more detailed that you as a lawyer get in giving the response to the pitch and the beauty contest, the more and more it looks like you're actually providing specific advice regarding specific matters. This is how I would handle this case. This is what we think the issues you're facing with respect to this particular matter, and this is why we think we're the best ones to handle it. We just got to understand that you probably are moving beyond a prospective client into a potential client because you're giving legal advice. And once you get to that point, then you have all these other ethical obligations that come into play. So just be aware of what it is that you are doing. Simply because someone does not hire you does not mean that you have no obligations whatsoever. If someone is a prospective client, or if someone turns out to be a former client, someone you've given legal advice to but hasn't actually hired you, they fall into a former client category. You have obligations to protect their confidential information, and guess what? You can't take any case adverse to the matter that they consulted you on, even though they didn't hire you. So this is why it's in your favor to really, really cut those discussions off at the outset so you don't cut your own legs off and to prevent yourself from being able to handle a case because someone got to you first. And this is even worse if they're actually not approaching you in good faith, and they're just trying to cut you off. There are people who will actively try to disqualify you. They will call every lawyer who is well known in a specific area of law, and they will feed them confidential information with no intent ever of hiring them. And what they're doing is they're trying to make sure you can't be hired by the other side. And that's just something you don't want to get caught in doing. If you end up you talk to somebody, you decide not to take the case, it's really important in our perspective as a risk management tool to send a non-engagement letter saying you have come to talk to me. We are not going to move forward with your case. We are not your lawyers. And that will give you a good piece of evidence to say, look, you did not handle that case and there were no obligations leading from that consultation. I will tell you we do handle a fair amount of cases of people who do a very, very short consultation. The next thing you know, years down the road, that client comes back and says, hey, I thought you were my lawyer, and guess what? You didn't file my case on time, and now, I've lost $10 million worth of claims, and you're the one who has to be responsible for that. And you start to get into issues of states of minds and what everybody thought, and that's harder to defend. So if you have a non-engagement letter, it's much cleaner. We've already talked a little bit about these unintended clients who might be prospective clients. Just watch out for these type of fact scenarios that might create situations where you have people who think they're clients and you're talking to them like they're clients, but you don't think they're clients and you're not treating them as clients, and then you have the recipe for a misunderstanding and some significant potential exposures because if you don't think they're your clients, you're probably not treating them as clients, and a lot of times there are a lot of mistakes that fall into that hole. Again, this is also a very, very active area where we end up defending claims on the litigation side. So the final slide, because I am over time, is what to do if the client turns on you. We don't have a lot of time to talk about this, but one thing that, Ellen said in the beginning, this is if they turn on you, they start screaming and yelling, they're screaming malpractice, they're screaming a disciplinary violation, they're going to make a claim against you. Ellen said you probably should think about hiring a lawyer. I will tell you this, I think it's a really, really good idea beyond thinking, but actually do it. Your perspective in a situation like that when you are being attacked is not good. In fact, not only is it not good, it's actually very, very bad. And all of your defensive mechanisms have come into play. And just think of yourself as this little teeny tiny person standing facing this three-headed dragon. And what's going to be your response? You want to defend yourself and you want to lash back, and that's when we start seeing emotional responses. We see people responding in anger, and the reality of it is you are a lawyer, and no matter what the provocation is, people do expect you to behave professionally, and they will be very unforgiving of unprofessional behavior, and having somebody help you manage that will kind of, I think, buffer a lot of the stress of a claim. So I think that is, I am over time, so I'm sorry about that. But I think we now can have time for some questions if anybody has any.
All right. One of the questions I received at this point is it an ethical issue to use internet banking for a client trust account?
So it's an interesting question, and what I can tell you is, under the model rules, it is not entirely clear. It's an issue that is arising with more and more frequency, and it's probably going to be that's probably going to continue to be the case. What I can tell you that is a little more substantial is that, for example, Wisconsin has recently adopted changes to its rules of professional conduct to say that it is okay for lawyers to use e-banking for their trust account deposits and disbursements. Those changes just went into effect in July of 2016. But if you're going to do that, you're going to have to keep in mind that you need to look back at the other rules of professional conduct and see what other types of concerns might arise. In addition, for example, we talked about confidential client information. In the context of cloud providers, I would say that the similar concern arises there. How do you maintain proper records for those trust account transactions? What security measures are there to protect not only the funds, but the account information? So these are all things that you would have to think about, and I would highly recommend, if you're thinking about doing this, not only check the rules in your jurisdiction, but consult with the discipline agency. Many of these discipline agencies have not necessarily ethics hotlines, if you will, where they're going to give you ethics advice, but they will direct you to resources. State and local bar ethics opinions, ABA ethics opinions. We don't have one on this right now, but this is an issue that's going to continue to come up. And the other issue that they have said in Wisconsin is there are some restrictions with regard to how those funds can be disbursed from e-banking. So it's a new and emerging issue, and I think it's one that is going to continue to create questions. So hopefully we will have some more ethics opinions coming out on this. There was one in Wisconsin in 2014 that said you can't do it. And now it appears that the Supreme Court of Wisconsin, after further study, has decided that it's okay under certain circumstances and adopted rules accordingly.
All right, thank you so much. So we have a question from Claudia, who asks, can you be counsel for a nonprofit if your spouse is a member of the board?
Wendy, you want to try that one?
That's a really interesting question. I think that raises potential conflicts of interest um, because the board would be making decisions and the lawyer would be giving counsel to the board on what their options are. And there may be potential conflicts because of the nature of your personal relationship with the spouse. So I think that it's technically possible, but it's probably not a good idea. And if you do it, you need some significant conflicts and disclosures and waivers involved, and you also need to, I think, set up some objective protocols at the outset that you guys will follow if there are issues that come up where this conflict is going to get triggered. And so you guys have something that is already set in place that you can follow that everybody's agreed on. But I don't think it's a good idea because the potential for that going wrong, I think, are pretty good.
I would agree.
All right. For the sake, so bear with me on this next one. It's a little bit longer. Maria asks, if I receive a $50,000 settlement check from defendant, my fees are $8,000 and lawyer B's fees are $2,000. After I communicate with the client and send him my bill and transfer my earnings to my account, how will lawyer B cash his money?
So if you are receiving the entire $50,000, you have an obligation to deposit those monies into your client trust account, to pay the client what he or she is owed, to pay yourself, and then to pay the other lawyer. Because you've received all the quote-unquote earned fees. So under the ethics opinion, and as I described it, I believe that would be the process. That lawyer, that second lawyer who is owed the $2,000, qualifies as a third party, so you've got to run that through your trust account.
Okay. Next question is it ever a good idea to meet a prospective client outside of the office?
Well, I mean, I think where you meet a prospective client really probably doesn't matter as long as you're following you're following the correct procedures. The reality of it is, in the real world, you're going to be meeting prospective clients all over the place. In fact, you always hear stories. I had this one partner who never gets off a plane without finding a new client. She's just that good. It's a captive audience. She's just very good at that. And so, it's hard to do it it can be hard to do it because some of what we talked about in the conflict checking, you want to be able to handle that beforehand if you can. And but it doesn't mean that you're going to be in a perfect situation if you're physically sitting in the confines of your office. So I don't think it ultimately matters where it's happening as long as you are following all the things that you need to do before you do that consultation.
Okay. And right dovetailing off of that as we wrap up, we have a question asking if you have any suggestion of apps or programs to use for conflict checks.
There are a lot of programs out there that are available for conflict checking, and I think they are sized to the nature and the size of your practice. And so a program that is really, really good for a small practice and for this type of practice is very different than one that is going to sustain a multinational firm with thousands of lawyers. And so that is a difficult question, I think, to answer in the abstract. I do think that the ABA does have a technology resources. They have technology resources in a law practice management section whose one of their missions is to go over a lot of these types of potential programs and what they might be good for and what they might not be good for. And I would just suggest that you look into those resources and try to find the best fit for your specific firm. Also, your insurance broker may be someone who could help you with that as well when you ultimately get an insurance broker for your whatever liability policies that you end up putting in place. They have a lot of understanding about the differences of these types of programs as it pertains to specific types of practices, and they can help you as well.
I would also just briefly add to that, you will have typically a law practice management advisor at your state or local bar association. These folks are incredible resources with regard to issues like that, not just conflicts checking software, but law practice management software, et cetera. So I would also urge you to reach out to those people and take advantage of their knowledge and expertise.
Fantastic. Well, thank you so much, Ellen and Wendy, and thank you to everyone who joined us for Steering Clear of Lawyer Discipline. On behalf of the ABA Law Student Division, the ABA Center for Professional Responsibility, and the ABA Young Lawyers Division, we want to say thank you for joining us today. Take care and have a great day. Thank you so much.